For just one time, I would take
the Northwest Passage. In Canada, it's the subject of songs and of famous explorers. But does Canada actually own the Northwest Passage, or is it an international waterway? In this Lycaeum Explainer video, we look at some of the history and politics of the 1985 Polar Sea incident and ask, does Canada own the Northwest Passage? In the late summer of 1985, the U.S. Coast Guard icebreaker the Polar Sea sailed through the Northwest Passage, seemingly in defiance of Canadian Arctic sovereignty. The icebreaker entered and transited the passage without asking permission of the Canadian government. This event stirred up intense public controversy in Canada, to the point that a Canadian civil organization, the Council for Canadians, privately hired a Twin Otter aircraft to buzz the icebreaker as it sailed through. They also dropped a canister onto the ship's deck with Canadian flags and a message stating that the ship was in Canadian territory. Reports of the Polar Sea's passage made the Canadian national news.
The Polar Sea, a ship from the U.S. Coast Guard, will start winding its way through the Northwest Passage on Thursday. The trouble is the Americans haven't asked for our permission, and they say they don't have to because the passage is an international waterway.
At issue was the status of the Northwest Passage, a waterway that passes through the Aleutian Islands, an island archipelago belonging to Canada. No one disputed the sovereignty of the islands, but Canada and the United States disputed the sovereignty of the waterways within the Arctic archipelago, especially the status of the Northwest Passage. For decades prior to the Polar Sea transit, the United States government had maintained that the Northwest Passage was an international waterway. About 15 years before the Polar Sea transit, an American oil company, Humble Oil, made a major oil discovery in northern Alaska. To find out if the Alaskan crude oil could be carried by ship to refineries on the American eastern seaboard, Humble Oil refitted and sailed the world's largest supertanker, the SS Manhattan, through the Northwest Passage to test it as a shipping route. The Manhattan was accompanied by a U.S. Coast Guard icebreaker, the Northwind. Neither vessel requested Canadian permission for the transit. The American government maintained that the Northwest Passage was an international strait and that it didn't need to ask Canada's permission for the voyage. The Canadian government responded very cleverly to the Manhattan voyage. The government figured that simply claiming the Northwest Passage for Canada would provoke the United States to deny Canada's claim on the grounds that it violated international maritime law. And the United States would have had a good point. In 1969, most countries agreed that a state could only claim 3 nautical miles off its coast as a maritime boundary. Those rules changed in the years following and were extended to 12 nautical miles, but customary maritime law at the time held that anything beyond 3 nautical miles were high seas, where nobody owned the water. In simple terms, the Canadian government did not claim sovereignty over the Northwest Passage, but instead passed what was called the Arctic Waters Pollution Protection Act, which created a pollution protection zone extending 100 nautical miles from the coast. Within the pollution protection zone, foreign ships had to meet design standards set by the Canadian government, and specially designated Canadian federal officers were given authority to board, inspect, and arrest ships that failed to meet those standards. The Arctic Waters Pollution and Protection Act gave Canada effective control over foreign ships passing through the Northwest Passage. When the SS Manhattan returned to the Canadian Arctic for a second trial voyage in 1970, Canadian inspectors boarded the Manhattan and inspected it before it entered Canada's new pollution protection zone. The Arctic Waters Pollution Prevention Act delicately solved the Arctic sovereignty crisis that Canada faced in 1969. Canada was also able to secure a certain amount of international acceptance for the Act. Maritime pollution was a big issue in the 1960s, and while the Arctic Water Pollution Protection Act was designed to resolve a territorial issue, it could be argued that, sovereignty aside, this kind of bold environmental maritime protection was needed to protect the delicate ecosystem of the high Arctic. The pollution aspect of this issue was benefited by a major international agreement called the United Nations Convention on the Law of the Seas. Article 234 of the Convention gave states with ice-covered waters special permissions to regulate shipping through those areas. For Canada, this meant that it could make special requirements for ships passing through the Northwest Passage. The United Nations Convention on the Law of the Seas, or UNCLOS, did not give Canada sovereignty over the Northwest Passage. In fact, a separate section of UNCLOS designates certain waterways for international navigation, specifically, quote, straits which are used for international navigation between one part of the high seas and another. The United States government insists that the Northwest Passage is an international strait, and there is a strong case for this position. The Northwest Passage connects the North Pacific to the North Atlantic. It provides a direct shipping route between East Asia and Europe that is significantly shorter than the Panama Canal. The United States government insists that even if the Northwest Passage hasn't been used historically as an international waterway, that doesn't mean it wouldn't be an international waterway under the right conditions. And thanks to climate change, conditions are getting more favorable for commercial shipping. But back in 1985, the issue at hand was whether or not the U.S. Coast Guard had rights to sail through the Northwest Passage without Canadian permission. The U.S. said that they did, and that they could back up their position with the rules of international maritime law. The Canadian government in 1985 responded to the Polar Sea incident by claiming to the Northwest Passage for Canada. On January 1, 1986, the Canadian federal government issued an order in council stating that all the waters within the Canadian archipelago belonged to Canada. Canada's Secretary of State for External Affairs, Joe Clark, made the following statement about the order. Canada is an Arctic nation. The international community has long recognized that the Arctic mainland and islands are a part of Canada like any other. The policy of the government is to preserve that Canadian greatness undiminished. The policy of the government is to maintain the natural unity of the Canadian Arctic archipelago and to preserve Canada's sovereignty over land, sea, and ice undiminished and undivided. Later in the year, the federal government issued an order in council called the Territorial Sea Geographical Coordinates Order. It essentially defined a boundary around the Arctic archipelago and claimed the waters within that boundary as Canadian territory. The Canadian government didn't just make up this boundary claim, it adopted the approach of boundary making from rules set out in UNCLOS that said a country could enclose bays and inlets with a straight baseline, where the waters inside that line are territorial waters. The Canadian government also said that it had historic title to the Northwest Passage owing to Inuit who have used the sea and ice in the Arctic since time immemorial. The justification for this comes from something called the Norwegian Fisheries Case, a maritime boundary dispute settled between England and Norway by the International Court of Justice in 1951. The Norwegian government was permitted by the International Court of Justice to claim a territorial sea enclosed by straight baselines, drawn from islands that were more than 3 nautical miles off the coast. Because Norway could prove uncontested historic usage of the waters, the International Court of Justice ruled that it could, therefore, claim the waters as internal waters based on so-called historic title. There's a lot more detail on the judgment than this, and you can check out the whole case summary on the International Court of Justice website. The link is in the comments below. The Canadian government reasoned that it could claim the waterways of the Arctic archipelago under the same principles explained in the Norwegian Fisheries Case, but there were some problems. The longest of Norway's baselines was 18.5 nautical miles long, whereas some of Canada's claimed baselines were more than 130 nautical miles long. Normal limits for baselines under UNCLOS are 24 nautical miles. Concerning the historic validity of the claim, where Norway had a number of internationally recognized royal decrees relating to their maritime claim that dated back to the early 1800s, Canada's first official claim to the passage had only come in 1986. There were unofficial claims before that. For example, in 1907, a Canadian senator argued that Canada should be free to exercise sovereign jurisdiction within a wedge-shaped sector all the way up to the North Pole. But this so-called sector theory never became official Canadian policy, and it remained unclear, even among Canadian officials, if the sector theory applied to land and water or just to land. Before 1986, it remained unclear what exact maritime areas Canada officially claimed. Was there any international recognition of Canada's 1986 claim? After the Polar Sea Transit, Canada and the US disagreed on the status of the Northwest Passage and signed a bilateral treaty in 1988 called the Arctic Cooperation Agreement. This treaty made two essential points. First, it said that the government of the United States pledges that all navigation by U.S. icebreakers within waters claimed by Canada to be internal will be undertaken with the consent of the government of Canada. This, in some ways, was a big win for Canada, and there is a good argument to be made that this part of the treaty acknowledged Canadian sovereignty over the waterway, and continues to strengthen Canada's sovereignty over the waterway the longer this agreement remains in force. However, the 1988 treaty had another clause, which said, "Nothing in this agreement of cooperative endeavor, nor any practice thereunder, affects the respective positions of the governments of the United States and Canada on the law of the sea in this or other maritime areas." In other words, both countries agreed that their legal positions would not be affected by any outcome of this agreement. In effect, Canada agreed that nothing in the agreement gave it any enhanced title to the Northwest Passage. This treaty remains the most recent agreement between Canada and the United States with regards to the sovereign status of the Northwest Passage. There is still ongoing disagreement between the two countries about the status of the Northwest Passage. In May of 2019, former Secretary of State Mike Pompeo said that, quote, "We recognize that Russia is not the only nation making illegitimate claims. The U.S. has a long contested feud with Canada over sovereign claims through the Northwest Passage." Canada's former Minister of Foreign Affairs, Chrystia Freeland, responded to that statement, saying, "Canada is very clear about the Northwest Passage being Canadian. There is both a very strong historic and geographic connection with Canada." A few months later, in 2019, the Canadian federal government released its Arctic Policy Framework, which stated that Canada's Arctic sovereignty over the region is long-standing, well-established, and based on historic title, and founded in part on the presence of Inuit and First Nations since time immemorial. A 2013 policy statement from the Obama White House stated clearly that the U.S. Arctic strategy was to see the Northwest Passage recognized as an international waterway. And if the U.S. Navy's 2021 Arctic policy is anything to go by, it doesn't look like the U.S. has much interest in changing its position that the Arctic waters are international waters. So it seems hard to say what the status of the Northwest Passage is now, or what it will be in the future. The Canadian government, based on its policy statements, appears determined to claim the Northwest Passage based on historic title. Canada has a case for its claim, and there is a lot of Canadian history that involves the Arctic. But as far as Canada's legal claim to the Northwest Passage, based on historic title, it may be wise to consider what the international implications might be, especially considering other countries pushing claims to historic waters. This video was produced as a part of the Lyceum YouTube channel, a forum for discussion on politics, history, and current events. Please leave us a comment in the comment section below, and you can also check out some of our other videos on the Lyceum channel. The sources used in producing this video can be found in the video description.